In recent months, renewed public attention has focused on the Archewell Foundation, the nonprofit organization founded by Prince Harry and Meghan, the Duchess of Sussex. Online discussions and formal complaints from members of the public have raised questions about compliance filings, transparency obligations, and the broader management of the organization. At the center of the conversation is a basic issue that governs every public charity operating in the United States: documentation. Registered nonprofits are required to file annual tax returns and, in many cases, provide copies of those filings upon request. These documents allow regulators and donors to review how funds are collected, allocated, and reported. When delays or administrative lapses occur, scrutiny tends to follow, especially when the organization involved is associated with globally recognized public figures. According to publicly accessible regulatory databases, Archewell has experienced filing irregularities in past reporting cycles. While filing extensions and corrections are not uncommon in the nonprofit sector, repeated delays can attract attention from both regulators and members of the public who are seeking clarity. Reports indicate that multiple individuals submitted formal requests for financial documents connected to the foundation. Public charities are generally required under federal law to provide certain filings if requested in writing. Whether responses were delayed, misdirected, or handled through third-party processing systems remains unclear from publicly available information. However, the perception that requests went unanswered fueled further complaints. When complaints accumulate, particularly in writing, federal and state oversight bodies may conduct reviews. It is important to clarify that a review or inquiry does not automatically indicate wrongdoing. Regulatory agencies routinely examine nonprofit filings to ensure procedural compliance. In many cases, matters are resolved administratively through documentation updates or fee payments. Nevertheless, the involvement of regulators changes the public narrative. What may begin as paperwork oversight can quickly become a reputational issue, especially for a high-profile foundation tied to prominent individuals. Complicating matters further are state-level compliance requirements. Nonprofits operating in California, where Archewell is registered, must file annual reports with the California Department of Justice's Registry of Charities and Fundraisers. Missing a filing deadline can temporarily change an organization's status to delinquent until required forms and fees are submitted. A delinquent designation does not automatically imply fraud or criminal behavior. In many instances, it reflects administrative delay. However, when viewed alongside federal scrutiny and public criticism, it contributes to a broader perception challenge. Perception, in the world of philanthropy, can be as consequential as technical compliance. Archewell was launched in 2020 amid significant media attention. Positioned as a platform for impact-driven initiatives, the foundation aimed to support community-based projects, digital safety efforts, and humanitarian partnerships. The organization also functioned alongside the Sussex's media ventures, creating a blended identity that combined charitable work with storytelling and advocacy. That hybrid structure can create complexity. Nonprofits must maintain strict separation between charitable activities and commercial endeavors. Clear accounting boundaries are essential to preserve tax-exempt status and donor trust. Recent headlines have focused on a reported structural shift within the organization. A reconfiguration, described publicly as an evolution or expansion, introduced a new entity under the broader Archewell umbrella. Organizational restructuring is not unusual. Foundations frequently adapt their legal frameworks to accommodate new partnerships, fiscal sponsorship arrangements, or programmatic shifts. However, timing matters in public discourse. When structural changes occur amid compliance questions, critics may interpret them as reactive rather than strategic. There is, at present, no public evidence confirming criminal misconduct, but there are legitimate questions about administrative consistency, transparency responsiveness, and operational efficiency. Financial filings from prior years showed that Archewell reported millions in revenue and expenditures. A substantial portion of nonprofit budgets often goes toward administrative costs, consulting services, program development, staffing, and communications. The nonprofit sector routinely debates what constitutes an acceptable ratio between operational overhead and direct charitable disbursement. For public-facing organizations, clarity around that ratio becomes crucial. Donors and observers want to understand how funds translate into measurable impact. Another dimension of the controversy involves broader brand perception. Since stepping back from royal duties, the Duke and Duchess of Sussex have positioned themselves as independent advocates operating outside traditional institutional frameworks. That independence, however, places greater responsibility on internal governance. Unlike royal foundations supported by established palace infrastructure, Archewell operates in a competitive philanthropic and entertainment landscape. It must manage regulatory compliance, public expectations, and media scrutiny without institutional shielding. The foundation's critics argue that inconsistencies reflect deeper organizational instability. Supporters counter that high-profile entities often face disproportionate criticism and administrative challenges due to the sheer volume of attention may attract. The truth may lie somewhere between those positions. Regulatory review processes are typically methodical and slow. Agencies assess documentation, request clarification, and determine whether penalties or corrective actions are warranted. Outcomes can range from simple fee assessments to more serious enforcement actions if violations are substantiated. Until official findings are published, any definitive conclusions would be premature. Yet, regardless of regulatory outcomes, the reputational impact is already unfolding in real time. Public trust in charitable institutions depends heavily on transparency. When documentation appears delayed or communication seems inconsistent, confidence can erode quickly. For Archewell, 2025 was widely expected to mark a renewed push in media and philanthropic initiatives. Instead, headlines have shifted toward compliance questions. Whether this moment represents a temporary administrative setback or a deeper structural challenge remains to be seen. One fact, however, is indisputable. Public charities operate under legal frameworks designed to ensure accountability. Fame does not exempt an organization from those requirements. At the same time, scrutiny does not automatically equate to guilt. The coming months will likely determine whether Archewell's situation resolves through routine administrative correction or evolves into something more consequential. For now, the central issue is not speculation. It is documentation, and the clarity that documentation either provides or fails to provide.
Beyond compliance questions, the Archewell discussion intersects with a larger narrative surrounding the Duke and Duchess of Sussex's post-royal life. Since relocating to California, the couple has pursued a combination of media production, public speaking engagements, and philanthropic initiatives. Early streaming and podcast deals generated substantial public interest. Over time, however, audience reception has been mixed. In the modern media economy, momentum matters. Streaming platforms and corporate partners evaluate success through viewership data, engagement metrics, and brand alignment. High expectations accompany high-profile contracts. When projects do not meet anticipated benchmarks, recalibration often follows. This commercial dimension inevitably influences perceptions of the foundation as well. When charitable branding overlaps with media ventures, critics sometimes question where storytelling ends and philanthropy begins. That does not inherently invalidate charitable work. Many public figures operate foundations alongside commercial enterprises. The key distinction lies in governance transparency and clear structural separation. Recent restructuring within the Archewell framework appears intended, at least publicly, to signal evolution. Foundations frequently adjust legal entities to streamline operations or broaden mission scope. However, such transitions must be clearly documented and communicated to avoid confusion. Another recurring theme in public discourse involves the couple's children and the role of privacy in their public image. The Sussexes have consistently emphasized a desire to protect their children's identities from intrusive media coverage. At the same time, limited glimpses shared through official channels occasionally spark commentary about branding strategy. Public figures face an inherent tension between privacy and visibility. Some choose full exposure, others opt for near-complete withdrawal. The Sussex approach has occupied a middle ground, which can invite speculation from both supporters and critics. Comparisons to other members of the British royal family often amplify that scrutiny. The Prince and Princess of Wales frequently include their children in carefully structured public events tied to official duties. These appearances are integrated into long-standing institutional traditions. By contrast, Harry and Meghan operate outside that framework, crafting an independent model that blends philanthropy, advocacy, and media production. The divergence in structure inevitably fuels comparison narratives. It is also important to distinguish between commentary and verified fact. Claims about internal intentions, financial motives, or personal strategy frequently circulate online without substantiated evidence. In high-profile situations, speculation can quickly overshadow documentation. The immigration status of Prince Harry has also been debated in public forums following admissions in his memoir about past drug use. However, immigration determinations are governed by confidential legal processes. Without official rulings indicating violation, conclusions remain speculative. Ultimately, the Archewell situation sits at the intersection of governance, branding, and public expectation. Non-profit compliance issues, if confirmed, can often be resolved through corrective filings, fee payments, and procedural updates. More serious enforcement actions require demonstrable evidence of intentional misconduct. From a reputational standpoint, however, even administrative missteps carry weight when associated with globally recognized figures. The Sussex brand was built on themes of independence, service, and reform. That positioning created both opportunity and scrutiny. When challenges arise, critics frame them as evidence of deeper flaws. Supporters frame them as exaggerated attacks. The broader lesson extends beyond one foundation. In the digital era, transparency gaps are magnified instantly. Every missed deadline becomes a headline. Every structural change invites interpretation. For Archewell, the path forward likely depends on clarity, updated filings, proactive communication, and demonstrable impact metrics. For Harry and Meghan, the moment represents another test in a post-royal journey marked by reinvention attempts, commercial experimentation, and persistent public polarization. Regulatory reviews follow established processes. Media narratives do not. Until official determinations are issued, the responsible position is cautious observation rather than definitive judgment. The outcome may ultimately prove less dramatic than online commentary suggests, or it may mark a turning point in how the Sussex enterprise is structured and governed. Either way, the principle remains constant. Charitable status carries obligations. Public visibility magnifies them. The story ahead will not be defined by speculation, but by documentation, by what filings show, what regulators conclude, and how the organization responds. That's where the real resolution lies.